Good afternoon, everyone. So, as you know, the topic is changing landscape of mergers and acquisitions in India. Mergers and acquisition, I mean, I don't need to be the first one to say this or stating the obvious, there are a whole bunch of complexities coming right from structuring of the transaction itself, at the term sheet stage, during the transaction, diligence related issues. And of course, there could be a whole lot of issues which arise even at a post-closing stage. How well are you going to integrate the acquisition itself? What are you going to do with it? How is the future growth coming along? Are there any other kind of issues? So there's going to be like a whole bunch of issues which one ends up dealing with during the life cycle of an M&A transaction. What we will try to do during the course of this particular session is to cherry pick like a few issues which have come about of late, and which a whole bunch of M&A lawyers are dealing with, some issues which they're even grappling with. So which is why we have this particular panel who, at least based on my interactions, I do believe that they have a fair degree of deep expertise to deal with these kind of issues. So anyway, so I'll just get started on the very first question, and I think this is taking off from one of the previous sessions which had come about to do with ESG. And ESG has become like a big mantra, and there are like a whole bunch of pros and cons revolving around the use of ESG, the scope of ESG as so much. And there are a lot of people who even don't believe in ESG. From a business perspective, Professor Ashwath Damodaran says that ESG may not be a very sound metric, so on and so forth. But I think one thing all of us agree upon is that ESG is here to stay. And and it has become a very, very essential factor of any kind of fundraising, as well as any kind of M&A transaction. So let me just pose the first question to Seema here, as to what are the critical issues which you are looking at it specifically from an ESG perspective. These days, what happens in the course of a diligence is that there is like an ESG specific diligence which happens. And let's say if there's an adverse finding, how does one deal with it? Or or what do you think are a critical factors which one would look at while evaluating a particular transaction from an ESG perspective?
Good evening, everyone. So basically, in the M&A space, the determination of ESG, which basically means whether the company is having good practices, ethical practices with respect to environmental protection and social and issues related to corporate governance. Now, the determination of ESG is not a trend anymore. It's not something which has come up in the recent past. It is a necessity, and I'll give you the reasons why it is a necessity. Because if you are a ESG, and there are multiple reasons for that, and one of the biggest reasons is in the M&A space. When we're looking at the M&A space, we're largely looking at companies acquiring you. Now, for you to become a very attractive investee company to be acquired, ESG compliance is a must. Because if you're an ESG compliant company, your valuations will be much better. Your readiness to deal with regulatory issues, your readiness to deal with any kind of employment issues related to environmental issues will be very fast. The second issue is when we as M&A lawyers look at the due diligence report, it's been there for a very long time, but now it's critical that the due diligence list has multiple factors related to and dedicated to ESG. And why is so? The reasons are multiple-fold. For the first is the exposure, the regulatory exposure that the company which is not ESG is compliant and you're trying to acquire them, your regulatory checkpoints will be very high. Such a company is a financial risk. So question number one for an investor is this entity an investor risk? And how is this a risk from a financial point of view? So if you are poorly managed, corporate compliances are badly managed, your employment issues are not well addressed, your employee relationships are poor, the question of your risk as a financial risk is very high. The second aspect is the reputational risk. Will a scandal come out? Whether a huge environmental risk potential will come out, and whether it will impact your customers' confidence, whether it will impact your future investor confidence, and therefore diminish your shareholders' value. So therefore, the reputational risk is very high. The other is what most people forget is that the merger or acquisition integration. So if you don't have your policies aligned with ESG, the investee companies' policies are not strategically and culturally aligned with the acquirer company, what happens is that becomes one of the biggest reasons for the M&A disaster. So 3/4 of the M&As fail in the world, and one of the biggest reasons is post-integration issues related to attrition of the employees, because their mapping of the ESG policies haven't been done. So that's a big risk. Your whole M&A can fall through. The other risk is, are you potentially a company where attrition is going to happen and talent will be attracted? So ESG is a big reason. What are your work policies? What are your policies related to employment and issues where the talent gets attracted? So therefore, toxic ESG company is a total no-no when it comes to large transaction. And even when I'm seeing smaller transaction, companies which are not compliant with the ESG regulations, whether it is having a negative impact on environment, having a negative impact on the well-being of the employees, they are not looked at. Now, what happens when we are doing an M&A? Basically, if you're so once we have had the due diligence, we've identified a whole lot of ESG issues. Reps and warranties, your list of reps and warranties, and you are all lawyers here, becomes very long, and it is then followed by a large disclosure list. Now, reps and warranties related to ESG non-compliances then is followed with a lot of indemnities, and then the seller and the biggest potential for negotiation in any commercial M&A is reps and warranties and indemnity. And all of the lawyers are M&A lawyers, they will agree with me that indemnification gets kicked in less than 10% of the cases, but 90% of a transaction is spent on indemnification and reps and warranty negotiations. And the lastly is that when you have a lot of ESG risk, what happens is that if you're a promoter who's going to continue with the company, you also have deferred payment obligations. So that means you are selling your entire company today, but you will not get your payment right now because you will be having earnouts as a potentially earnout system of payment, or you will have your money in the part of the consideration in the escrow because you have a whole lot of ESG exposure. So ESG is a huge thing and needs to be looked at.
Absolutely, couldn't agree more. Just one follow-up question, and this is open to the panel as such. See, I always believe that, when you're doing an ESG diligence, you can identify issues from the E perspective, the S perspective. But how do you pinpoint and address issues from a governance perspective? Because governance issue is not just a diligence issue, it also becomes an ongoing issue. So, as lawyers, how do you evaluate the promoters? I know that it's not just, a business decision. Tomorrow if there are any issues against the promoters, it's going to blow back on the entirety of the company, entirety of the transaction as well. So, are there any kind of checks and balances which you're going to put specifically against the promoters, especially where the promoters continue to be part of the system and, they've not had a full exit? How is that, you try to, address the governance issues? Because, we are in a system where, even in M&A transaction where promoters continue to stay on the boards of the company, they continue to have a fair amount of say with respect to the operations and management of the company itself. So how does one protect against themselves against this kind of a governance risk?
So is this question to me or?
Anyone.
Okay.
I think Vaibhav.
So, briefly, when we do the due diligence, the governance issue gets identified very quickly. Something it starts as basically as, do you have the minute book ready? नहीं बनाएंगे जाके अभी. So that is the first checkpoint, that your attention to detailing of even the basic of the company law compliances are zero. So governance starts at starting to maintain your books, registers, minute books, and then it is followed by what is the attitude. See, the governance comes with the attitude of the promoters, and we have massively successful promoter-driven companies in India, and those are the companies where we see a lot of fraud and a lot of non-governance issues, and that is where the customers right now are putting a lot of pressure that we want to deal with the company which is reputationally good. And how does that reputation comes? Tata is a case in point, because when you deal with Tata, you will be dealing with an ethical company. So when we are doing the due diligence, you get a sense of what is going to succeed after once we have taken the control, and if the promoter is going to continue. And that is where the checks and balances are put in place.
Anything to add?
Yeah, no, I think I completely agree with Seema here. Particularly, there's also a new trend, Gautham, which is that if you look at a lot of listed companies which have just recently done IPO or done IPO in the last 2 years, the so-called technology platforms which are doing very well for themselves, the actual promoters and founders holding is abysmally low.
Right.
And this trend is going to continue. That by the time a company will get listed, firstly, there will not be an identified promoter group. There will be a professionally managed company with a particular founder. And very similar to what we see with Facebook, where Mark Zuckerberg's holding or Elon Musk holding in Tesla is very minuscule, they still enjoy a higher degree of control. Typically, even in companies such as those, because there's going to be such a huge institutional and public shareholder pool, it is extremely critical to keep viewing and keep scrutinizing any decisions taken by the management from the point of view of company's perspective. And increasingly, we are seeing two trends emerge. One is that because if you look at these big listed companies as well, the public shareholder pool is significant. Mutual funds, FIIs own very large chunks of shares. Promoter holding is dwindling down. And like I said, even in these professionally managed so-called tech companies, founders' ownership is no more than 5%, 7%. So proxy advisory firms are becoming very critical to carry the voice of the public shareholders. Inevitably, any related party transaction, any questionable transaction, you're seeing a lot of noise being created by the proxy advisory firms, which is the right thing to happen. SEBI also, many would argue from a listed company compliance point of view, have gone overboard. But I think it was necessary. It was the need of the hour. They've really tightened the regime on LODR regulations insofar as compliances by listed companies on related party transactions, the kind of disclosures that they expect. So actually, SEBI has done a very laudable task of looking at interest of that one equity shareholder holding 5 shares and looking at it from the point of view of that shareholder as to how interest of the company can be protected from any errant behavior by the promoters.
Right.
So that philosophical change has already happened. We are beginning to see a lot of proxy advisory firms become champion for the institutional and the public shareholders, questioning all the wrong transactions. Of course, our investigative agencies are also overzealous and overactive at the moment, which also means that transactions of this nature, which are errant, will get scrutinized, will get questioned. And then the third piece, which I must confess, it's a mystery to me why it is not taken off, is class action. I think, as many of you are aware, the Companies Act of 2014 brought in this whole framework of class action along the lines of what the US law on the subject matter was. However, they notified only NCLT Principal Bench Delhi as the relevant body to entertain class action proceedings. But that hasn't taken off as yet. And I'm quite shocked. In fact, there's so many times when, public shareholders or institutional shareholders are approaching us where there are issues of misgovernance by the promoters. They're all looking at filing complaints with SEBI. They're looking at oppression, mismanagement. They're looking at how any additional proceedings can be undertaken, criminal proceedings with the SFIO or with the EOW. But class action still hasn't taken off. I think in my view, in the coming year or so, 2024, you're going to see a lot more class action. You're going to see promoters who are errant, who have caused loss to the company, having to start to bear the burden. I think somewhere the fact that NCLT was highly overburdened with all the IBC cases has also contributed to that stress. But I think that will also happen as we move along. And the last point around this is that, especially in the startup space and companies which are in Series D, Series E, Series F, the venture capital investors and the private equity investors will never admit to it. But the reality is where we are representing them, inevitably, while there's a legal and a financial diligence taking place, they will also do a background and a forensic check on the founder.
Right.
So that's also started happening. They will share those reports on a confidential basis with their law firms to make sure that they also understand. But I think a behavioral perspective, a background check. We saw what happened in one of the large e-commerce companies which got taken over by a US giant. One of the founders ultimately had to leave on grounds of sexual harassment. We saw 1 or 2 founders of prominent tech platforms being thrown out of those companies. They're still litigating. So errant behavior of founders will happen. It is a reality. But I think it's important to have systemic checks and balances. And we're moving there, slowly but surely.
That's great, and I think this directly morphs into my next question of shareholder activism, because historically, at least, shareholder activism has been generally very poor in India. 15 years back, 20 years back, and all that. With all due respect, promoters could run riot, right? Because the mutual funds would not take part, the financial institutions would not take part. A big gun like LIC would not take part. They would just go with the flow, abstain, or go along with the promoters and things like that. But these days, because of these proxy advisory firms and all that, shareholder activism is also on the rise. And I think this also serves as some kind of ears to the ground exercise to people who are involved in the M&A transaction as to how shareholders are reacting, so especially so in the case of listed companies.
That's absolutely right, Gautham. And just a very quick observation. It all stems from the actual profile of shareholders of any listed company. You look at the last 15 years, and if you were to do a comparison, you will realize that promoter holding, very crudely put, Lala holding in listed companies has significantly gone down. And all the run-up that you're seeing in the stock market is being contributed by a number of mutual funds buying. I mean, the reality is, a slight segue, FPIs and foreign institutional investors have been net sellers over the last 3 years. But the Indian markets are continuing to go up. Why? Because a lot of public money is going back into the markets through the mutual funds. And therefore, they are going to become an important voice of reason. I was also involved in the specific whistleblower report that was put together in Fortis Healthcare when the erstwhile promoters of Fortis Healthcare allegedly siphoned away money from the company. And I authored that report. And I can share with you that ultimately, when we have looked back and seen some of the conduct, what we realize is that listed companies often, and the senior management, the entire establishment, they tend to believe that if there is a promoter, he owns 70%, he's the big boss, and I have to follow every instruction to the T. I think look at what happened with CG Power, look at what happened with Fortis Healthcare, look at what happened with Religare, look at what happened with Unitech. I think it's an important lesson for generally the professionals and the senior management that your stakeholder, the real stakeholder, is the shareholder. You have to make sure every decision is viewed from the prism and parameter of whether it's the right decision for shareholder interest. And just because your CEO or your MD or your promoter is telling you, cannot become the gospel truth. And people have learned the hard way. A lot of them have had to face SFIU investigations, pay significant penalties as part of SEBI proceedings on account of FUTP or other law violations. So I think managements are also realizing that promoter is not the end all, and you do not have to hear him for every word, and you'll have to do what is the right thing for the company. So that philosophical change is happening, but of course there will be a lot of collateral damage along the way, some of the names that I just took. But one hopes that things will get better quickly.
Yeah, no, I get that. And I think especially with respect to mutual funds, especially, I think they're finally playing catch up when it comes to shareholder activism, and considering, how consistently they have upped their stake in Indian companies, they have realized that, they shouldn't be passive shareholders, but should actually vote for resolutions or against resolutions, as the case may be. And one certainly hopes that, this trend will continue.
So I have some thoughts on what has just been discussed. I think shareholder activism is definitely rising, but it is also linked to the governance system that we have in place. And I think my personal belief is that we are a maturing regulatory system. With every passing year, we are reaching new heights. I wouldn't say that we are on a lopsided regulatory mechanism. Every year, based on the experiences of the regulator, there are changes that are being brought in, and that are being brought in for the protection of the public shareholders in case of a listed company, for example. As everybody very well knows, there is a concept of independent director, and in listed companies, they are the majority in certain situations. There are committees where the independent directors are a majority. So the checks and balances are very much there in place simply by virtue of a company being a listed company. So, you can expect that there is some level of diligence by the company and the management to ensure that wrongdoings are in check. On top of that, there are also some additional, protection in the form of majority of minority approval in case of certain M&A transactions. So it's not that the promoters can take, the public shareholders or the value of the company for a ride. And that's where, in such cases, like Vaibhav mentioned, proxy advisory firms play a very critical role. When it comes to majority of minority approval of public shareholders, where the promoters cannot vote, it is the external influence of these proxy advisory firms which play a very crucial role. Now, apart from the listed companies, there is also an unlisted space where, I would come back to the original question of governance. Unlisted space is where the governance system is maturing now. With investors coming in, they are putting in place the restrictions, the policies, the verifiable mechanism to ensure that no wrongdoing is happening. In many instances where the investors have not been satisfied, they have ordered their own audit on certain unlisted companies. Just to be sure that the audit reports or the financial statements that are being prepared, whether they are originally correct or not, or there's a gross deviation or not. We have seen instances where the investors have also gone for verification of, the assets of the company. That what the company is claiming is there in its financial statements is actually there on the ground or not. So, lot of activism of investors is also happening, and gradually it is increasing. And a very remarkable development is the ESG process. Like Seema mentioned initially, now the shareholders agreement for many private equity firms, they will not sign off on it unless the ESG clauses or ESG policies are ingrained into the shareholders agreement. And there is a proper reporting mechanism that is established. Now, this is gaining traction, and I think over a period of time, at least we expect that it will increase in the Indian legal system. And it will also ensure, it's also good for the public shareholders that subsequently if any company goes on for listing, it can, at least the public shareholders can have a bit of surety that because of the ESG policies in the company which have been enforced by the private equity investor over a period of time, the default would be very, very minimal or next to zero.
Got it.
So that's a very important development that has happened over the last decade or so.
Absolutely, and one hopes that the trend continues. But let me just move on to Deeksha as well, and this is also something which arises from, protection of the shareholders itself. So what we are trying to look at is the role and the impact of competition law, in the M&A realm, because, you would have signed up the documents, you would have agreed on the documents, but you still need to get a regulatory approval to go ahead with that. That is one. And the other thing, I was just going through the latest proposed draft amendments to the competition norms itself, this whole concept of deal transaction value, which, until before was not there within the scope of the Competition Act. Do you think that, these are things which are going to impact the M&A process? And if so, is it going to only stretch the timeline, or is it going to make the M&A process so much more complex?
So I think competition, much like other regulators, is a part of that missing jigsaw puzzle. You need it for completion. Thankfully, in India, we've seen a very facilitative environment. We are not in a place where, for instance, in US, if you don't get the approval, deals are actually cancelled, and not getting the approval is fairly common. It's not that unusual. It's also fairly common now in Europe. In India, we've till date not had a single denial of approval by the Commission. So we are in a fairly facilitative space, but it's not a space free of its risks. I'll touch on the deal value first, and maybe then just a couple of other points about how it impacts the M&A landscape. Deal value is being brought in with a certain background and context to capture deals where your target might be very small in size. So it might be benefiting from that target de minimis exemption of assets and turnover.
Right.
And the value is very high. So there's a mismatch between what the target is generating, what asset base the target has, and what is the value that is being given to it by the acquirer. And this happens typically in very, very few spaces. You'll see it in the tech space. You'll probably see it in the healthcare space, which are very, innovation-driven markets. So what you're generating and what you have may not really be equal to what promise you hold.
Because of the entire discounted cash flow, and then, the curve of...
And the deal value might reflect all of that. Right. So the deal value threshold is only to capture all of this. There's been a lot of noise around, oh my God, does it mean too many notifications? Yes, there will be an increase in notification because there's a gap the regulator is trying to capture. But I don't think that increase is going to be manifold, that all the deals that you were earlier going scot-free will suddenly get caught into the net now. It's a decent threshold. It's a threshold of 2,000 crore, very similar to the threshold that we have in Germany and Austria, which are the only two other countries that have deal value thresholds. And based on their experience, they've had probably less than 10% additional deals being notified. So I don't see a big jump.
So it's not as adverse as one makes it sound to be.
Yes, not that bad. Timelines is something you noted. Along with the deal value threshold, there was another set of amendments brought in which drastically reduced the timelines. As a regulator working with the commission and day in and day out, we've seen fairly quick approval timelines for simple transactions. For the complex ones, I think the parties themselves are fairly prepared for the additional time that's going to take. It gets reflected in all the documentation as well. So I think in timelines, there is a stress from the regulator as well to ensure that we don't really extend the timeline. But just very quickly, I think a couple of other things from a competition perspective is early stage feasibility assessments. We've done that on big deals, where, much before you actually come into the room to negotiate the agreement, you'll probably sit down and see whether the deal is feasible from a competition perspective, or whether some changes might be directed by the regulator which will make this non-workable. That, I think, is something we've focused in bigger transactions, but there's increasingly a need to look at it in smaller spaces as well.
Right.
Maybe you're acquiring a company because of the data that the company has. There is a need for you to examine whether that data might be siloed off, reducing the value of that company for you completely. So I think that is one aspect which, as competition and data regulations evolve, is something probably the M&A space will also have to account for.
Got it. Super helpful. So in the interest of time, I just have one set of last question. Again, from a regulatory perspective, directed at both Vaibhav and at Navin, since I know both of you do a lot of work on the regulatory side. The biggest regulator of them all, Bharat Sarkar, right? And again, let's just go back, rewind a few years to the entire thing about, Press Note 3 of 2020 and things like that. It has had a whole bunch of, unintended consequences, right? What you were trying to restrict is, inflow of funds from a particular country, but now it's actually becoming a whole lot of issue. European companies who are looking to undertake, M&A in India, they are having issues from a PN3 perspective because, indirectly they have had some kind of inflows or shareholding from the PRC. How is that one deals with this kind of scenario? Or does it also result in a scenario where now Indian promoters have to do some kind of a basic diligence on the acquirer to see if they're in compliance with PN3?
Thanks, Gautham. That's an excellent question. Look, I think let's not beat around the bush. The reality is that in the backdrop of COVID, in the backdrop of the border conflict, India, much like Australia and some of the other countries in Europe, took a political decision that we will not allow inflows from China without specific approval of the government of India. And that was a political decision driven by national security and other considerations, and we completely respect that. And post-2020, ever since that notification came in, true-blooded investment coming in from China into India has been a challenge, and government has put restrictions, and that's a conscious decision, and we all respect that. And there is some policy considerations that drove those deliberations, and we are not here to question it. What, however, has happened, which is unfortunate and a collateral damage and an unintended consequence, was private equity funds and venture capital funds.
Right.
A lot of private equity funds and venture capital funds, which are true-blooded American or true-blooded European, where the general partner of the fund is situated in Switzerland or in the US. Names such as those which would, in nobody's mind, leave even an iota of doubt, have no Chinese influence. And as anybody understands the fund structure, it is the general partner, it is the chief investment officer who takes all the decisions insofar as this investment is concerned. And the say of a limited partner who's putting in money is as much as you and I would have when we put in money in a mutual fund. We have no say how the manager decides where to invest, how much to invest, and when to dispose.
Pure play financial vehicles.
Pure play financial investors. So a lot of these global funds, of course, had a lot of investments from China as limited partners. But because Government of India till date despite the fact that now the Reserve Bank of India, under the KYC guidelines and under the PMLA, there's already a notification which lays down beneficial ownership to be 10%. But for various strategic security considerations and other fear of unknown, we are not willing to clarify what that beneficial ownership would be for venture capital funds and private equity funds. So true-blooded funds which are looking to invest in Indian corporates with Indian founders, with Indian management, Indian control, because they have some limited participation of a Chinese investor, those investments are now going under the approval route.
Right.
And approvals such as those are taking forever. You have an empowered group of secretaries that the government has constituted precisely for this purpose. But when these applications go to the Home Ministry for clearance, it's a bit of a black hole. And we understand those considerations, but it's taking forever for an Indian pharmaceutical company to be able to get investment from an American private equity major because there's an LP participation of 4% from China.
And in some cases, that is also resulting in collapse of the transaction itself.
That is correct.
Because the investor may not want to wait for indefinitely for 12 months or 18 months.
And also the converse, because Indian companies are now riding the growth wave, if I have struck a deal with you on X valuation, I will not hold that deal with you for that X valuation for the next 2 years.
18 months.
Because naturally I would ask for an upside because the growth is playing out right now. So that is becoming a complication. We really have been making a lot of representations to the government. We're hoping they intervene, they clarify what beneficial ownership means. But otherwise, what is happening is a European company, which at 4 layers above has a Chinese investor owning 3%. And you and I are having to now worry for our Indian client that would we end up tripping press note 3. Right. And there have been instances where such companies have had to be told by the government that you have to take out that shareholder and go for compounding under FEMA. So that's a bit unfortunate, unintended consequence of the overall objective on which we are not debating, and we understand and we respect where the government is coming from.
Right. Navin, quick thoughts.
Yeah, thanks, Gautham. I think Press Note 3 clearly was a political decision, and on most counts, I wouldn't say it's as bad as Vaibhav is saying. I think it was a conscious political decision not to have funds from certain jurisdictions, and it's playing out well. If you'll see the FDI trends also in India overall, it's on a rise. It's not reduced. That's one.
But it's making things
yeah,
lot more
I'll explain that.
Right?
So clearly there has been complications that are there. Now the answer is, and obviously the complications cannot be sorted in 1 year or 1 day. But if the question is it resulting in a loss to India at a larger level? I mean, I haven't come across any client who is saying that, particularly because of Press Note 3, we will not do the deal. It has not happened so far, not in my experience.
Yeah.
And
there are just to say what you just said. See, it is not the loss of fund really. It is also the loss of reputation and image.
Yeah, I'll come to that. I'll come to that.
Stroke, you have changed the entire policy, and the beneficial issue that Vaibhav has raised. This issue was raised right there and then.
Yes.
In 2020, that what do you mean by, and what is the threshold of the beneficial?
So I think
absolutely,
now
and it's not been 1 year.
No,
It's been 3 years now.
Now there's been a lot of clarifications on what SPO is. It's not 100%. One cannot claim that there is 100% clarity on every aspect of Press Note 3. But if you approach the regulator, they have the principles very clear. Earlier there was some lack of clarity around
Absolutely. Yeah. In fact, Gautham, I will add to say that there has been an amendment to the standard operating protocol, which has created more confusion.
Right.
Because now the government is saying you will go right up till the layer top. And there is no concept of 10%. And so whatever definition of beneficial ownership my friend Navin is talking about has not been, they've said we are not applying this in FEMA.
Correct.
And
so although Companies Act and PMLA are pari material legislations,
correct.
Our understanding is that these thresholds and these interpretations are not holding good for FEMA.
I think the short point is we
And
all
that is
support Government of India's position on PN3. We are all in respect of that. So it's not a bad thing, as I said. It's a good thing. Only problem is the unintended consequence on private equity and venture capital funds investing in India and global acquisitions where at some layer above, there might be Chinese interest because ultimately China was a far more developed country. It had far more capital. It was investing all over the world. So you will find remnants of that. Now the government will have to clarify eventually and not leave it for us to debate. And at least we have experienced deals blowing away because of the fact that there's no clarity whether government approval will come or not.
Right. Sorry. Since we're short of time, last questions, Deeksha. The new Digital Personal Data Protection Act, any impact or business as usual?
I think largely business as usual. You do a merger, you're doing some data acquisitions, you'll have to work around your consent mechanisms to ensure they're in line. The only thing you need to keep in mind is if data is one of the main or strategic reasons for acquisition of a company, that might have implications under data law, under the new Digital India Act, and under Competition Act. So where the data set itself is the reason why you're acquiring.
Right.
I think that is something that might have to be thought into, not time for us to go into it right now. So we leave it for another day.
Fair enough. Thank you so much, everyone. We are unfortunately short of time. Otherwise, I think we had a lot more questions lined up. Thank you, everyone.